NBC News correspondent Vaughn Hilliard, MSNBC legal analyst Lisa Rubin, and the New York Times' Adam Liptak, who's reporting on the behind the scenes of the Supreme Court I just mentioned. Adam, I do want to begin with you because I think you have some really insightful and meaningful detail in this piece. I want to start with when the court decided to take on the issue of abortion and how quickly it became clear that the conservatives had the majority to overturn it within the Supreme Court.
Well, so the standard account is that Ruth Bader Ginsburg dies, Amy Coney Barrett comes onto the court, and it's inevitable. It's going to happen. But in fact, they take months and months and months of internal deliberations about whether to hear the case. And our reporting shows that Justice Barrett ultimately voted against hearing the case. So the bare minimum of 4 justices, it takes 4 justices to put a case on the docket, did that. And while Justice Barrett ultimately voted with the majority to undo Roe v. Wade, our reporting shows that this was a much more complicated enterprise within the court to get it on the docket. And then even once it's on the docket, there were strenuous efforts made by Paul at the center of the court, Chief Justice Roberts and Justice Breyer, a liberal, to try to come up with a compromise, so much so that Justice Breyer actually thought about doing away with part of Roe to save the rest of it.
We're showing images of the Supreme Court as it's currently made up with Ketanji Brown Jackson. Stephen Breyer was on the court at the time that this reporting covers, and he, as you mentioned, was one of the justices trying to find a way to at least save some of Roe v. Wade. I am curious, though, in talking about the decision to take this up and where the heads were of the justices, I think it's important to go back to the confirmation hearings and to hear what Justices Gorsuch and Kavanaugh said about Roe v. Wade when they were asked about it by senators.
I said that it's settled as a precedent of the Supreme Court entitled to respect under principles of stare decisis. And one of the important things to keep in mind about Roe v. Wade is that it has been reaffirmed many times over the past 45 years.
The Supreme Court of the United States has held in Roe versus Wade that a fetus is not a person for purposes of the 14th Amendment. And the book explains that.
Do you accept that?
That's the law of the land. I accept the law of the land, Senator, yes.
So, Adam, when you listen to that, and from reading your reporting, it seems like those were hollow words from those 2 men who ended up becoming justices, that when they got in the court and when they were presented a case that could overturn Roe v. Wade, the idea that it was precedent no longer mattered.
Yeah, and they really didn't wait very long. I can listen to those words in 2 ways. As a layperson, it certainly conveys and seems designed to convey that they're going to leave Roe alone. To a lawyer, there's enough fudge in there about stare decisis and respect for precedent, and you don't ordinarily overrule precedent, but sometimes precedent can be vulnerable, that maybe gives them a little bit of daylight. But to the average American looking at the confirmation hearings, they would not have come away with the impression that those 2 Trump appointees, and recall that President Trump had vowed to put people on the court who would overrule Roe, that these 2 Trump appointees were eager participants in that project that they turned out to be.
Yeah, but those confirmation hearings are not arguing in front of a court. They're arguing in front of Congress, and that's a message to the public. So I know that
Yes.
legalese, but certainly if you are a layperson, that's what you would take away. And that's who they were, supposed to be talking to. Let me ask you about Chief Justice John Roberts and where he fell on all of this.
Well, John Roberts didn't want to take the case, and he had, in an earlier case, albeit in a limited way, voted in favor of abortion rights. And then once the case was taken, he found a middle ground where he would have upheld the law from Mississippi in front of the court that would ban abortions after 15 weeks. So that would be a significant blow, but it wouldn't be 0 weeks. It wouldn't be doing away with Roe. It would be doing away with the part of Roe that says viability is the dividing line and states can't ban abortions before viability, about 23 weeks. So he was working hard to come up with a compromise and to try to peel off one vote, maybe Justice Kavanaugh, maybe Justice Barrett. And as I said, Justice Breyer, a liberal, thought about joining that compromise position, undermining a part of Roe in the interest of trying to save Roe. But in the end, Chief Justice Roberts, the namesake of the Supreme Court, its nominal leader, was outflanked by 5 justices to his right and found himself with a lonely compromise position for which he was the only vote.
So let me ask you about the leaked draft. Remember, Politico got a copy of what the decision was ultimately going to look like well ahead of the decision coming down. And at the time, I guess the immediate thought was, this must have been leaked by somebody who is horrified by this and wants it to stop. But in reading through your reporting and much of what we've learned since then, it seems like by leaking a decision like that, what you do is not, potentially get it changed, but you solidify the position. You solidify the decision so that it can't be changed.
So I distinguish 2 things. We don't know the motive of the leaker, but we know the effect of the leak. And the effect of the leak was to make this difficult task of John Roberts trying to pick up a vote for a compromise position even harder. I mean, after the leak, the court grew wary of even using its electronic communication system, and Chief Justice Roberts, who was working on his concurring opinion for his compromise position, was wary of even circulating it. So even as a practical matter, it made his life harder. And as you say, quite correctly, the leaking of the decision and of the votes and of the 5 votes that had been tentatively cast for it would ordinarily and logically lock people in. They're not going to run away from their votes once they've been made public.